All right, this should be a good one. I had a man contact me from Northern Ireland who was helping a friend who had a traffic violation. Now, this is not a serious traffic violation. He didn't do anything like bad. It was a traffic violation. Well, I think he's at 40 hearings so far he's had in this matter. 40 for a traffic violation. So the good thing about that is he's cost him a ton of money if they did 40 hearings. He's had to cost him a boatload of money, which is a beautiful thing because he's a real bad customer, and we always like to be bad customers for them. You know, we always want to be the worst customers they've ever seen, so that they don't want us back there. They don't want to do business with us anymore. So this man contacted me, and uh, they what you're going to hear here is it's pretty amazing what you're about to hear actually. Uh, they had a hearing, and the judge is getting ready to start the hearing. You're going to hear this, and before the hearing starts, he asked the judge if he could speak to the prosecutor, and he asked her some really key questions, and I think you'll recognize a lot of the questions if you watch, my videos and you watch Robert Fox's stuff. You're going to recognize these questions, and you're going to see what happened because prosecutor got real squirrely and removed herself from the case, and they couldn't have their hearing that day. So they're going to have to line up another sheep to come in. Another pettifogger shyster sheep's going to have to come in and try and move this case against this man. And good luck with that. But it's a little hard to hear. Had a man do some cleanup here for me, and he did a really great job. The original audio was really hard to hear. A lot of background noise. He must have had a mic in his pocket or something. But did a real good cleanup job with this, and so it's a little hard to hear. They got the Irish brogues, and it's funny because I think they got accents, and they listen to me and they'll say I got an accent. So, but you're gonna make out the gist of it, and the reason I wanted to cover this and go over this is powerful stuff, man. When you go after these attorneys and you actually show them their liability. Because listen, these attorneys are used to skating through these hearings, and they're persecuting you from a perch up high, and they're going to take pot shots at you. And gee, when they miss you, they just want to dance off like nothing happened. Like there's no liability for them. Oh, I missed them. Let me move on. No. No, you get in their face, and this is a beautiful thing what he did because this is what things I've been hammering in a lot of my interviews is about agency. And what agency is, somebody asked me what agency is today. Listen, agency, these attorneys are agents, okay? Which means there has to be a principal that hired them. But here's the problem they have. When you say, who hired you? Who's the principal? They always run back to, well, the Crown hired me, or, the state of Texas, or the Commonwealth of Pennsylvania. Well, you and I know that there is no such thing as the Commonwealth of Pennsylvania. There's no Mr. and Mrs. Commonwealth of Pennsylvania that are going to come into court and going to say, yeah, I hired the attorney. So there's no principle, and there never is a principle. And when you start to run after these attorneys and they see that you're running after them, I don't think when the other party who may be the principal that hired them really is going to want to step forward and say, "Yep, I'm the man or woman that hired this guy to do these bad, damaging things to you," because it's liability. So generally, what you have is you have Mr. Attorney out there on an island by himself, and when you start pressing him for who's the, when he states what's your agency, what he's asking is, who's the principal that hired you? Like, in other words, what are you doing here? Why are you involved in this matter? Who hired you? And you'll hear her say the Crown or something like that, which is just ridiculous. Like, yeah, Mickey Mouse hired me, Donald Duck hired me. Yeah, yeah, and she'll dance around it, and we'll go over some stuff. And listen, they did a great job, these two guys. They really did. And I just want to hit on a couple things. And when I critique this stuff, listen, I'm not criticizing them. It's not like meant to be a bad criticism. I just look at it as an opportunity when something's said, I'll stop and I'll say, listen, here's where they should have went down this road. They should have asked her this or should have done this. But that's not a criticism. That's just a critique so that next time, now they can hone what they have here and perfect it and make life hell for these attorneys. So, yeah, let's sort of jump into it. And what you're going to hear at the first is it sounds like they're having a conversation with the clerk, and then the clerk's going to tell them dumb stuff like, you're going to love this, where she says, because of the COVID stuff and the pandemic, they got to sit, I think, at 2 meters apart, and she'll say, they're the rules. It's not me saying that; it's the rules. So these mystical rules, these mystical rules are walking around talking to people saying, "Hey, make people stand 2 meters apart from each other." These are ridiculous claims. So even in this early part, I would have said to her, "Whose rules are these? Who's saying I got to sit 2 meters apart from anybody?" And this is what you should do with these people. Never let them talk in we, they, us. No, you always want to hone it down to, listen, I need a name. If you're going to tell me that these are the rules, I'm going to need you to bring the man and woman forward that's stating that they have ability to make rules for me and tell me what I can and can't do. Because the rules for these courts, all these courts, are created by the legal society, the Bar Association. And the legal society is a private organization, and you and I don't belong to it. And they wouldn't let you and I belong to it, nor would we want to belong to their bar association. But these courts are supposed to be open public courts for the people. These are not the legal society's courts. So, where did we get off where this private legal society can come in and tell you and I, that the men and women, how we must access an open public court? And here's what they're doing, basically, and I think it's a good analogy. Is, listen, they drag you into these fights that you don't want to be in. They drag you kicking and screaming into these fights, and then they want to tell you how you can fight them. It's like tying your right arm behind your back and telling you, "Here's how you got to fight me, just with your left arm." No, you don't get to drag me into a fight, and then if you don't like the way I'm fighting, or put it this way, the ferocity of how I'm going to fight you. Because I'm going to take it to the end where I'm going to try and destroy you and your career. And if you don't like the way I fight like that, then you better get out of the fight. And you shouldn't have picked the fight in the first place. But I don't go for this, remaining in honor stuff. Bunch of crap. Listen, there's nothing honorable. That's like, remaining in honor. Somebody's robbing your house, and you catch them robbing your house. And how do you remain in honor? Me, I'm probably gonna I'm gonna pick up a baseball bat or worse if I got somebody in my house that's not supposed to be there. And that's what this is. These people are in your life. They're not supposed to be there. They're interfering in your life, and they're stealing from you and your family. And they may be ruining lives, a lot of lives. I mean, look at the way they put people in jail for just stupid stuff, that dumb stuff. So they're ruining people losing jobs, people losing houses, people people losing their lives. I mean, their liberty. This is all caused by the Bar Association, because these people are creating conflict where no conflict really exists, and it's all done for extorting money from you. So listen, if I'm dealing with a thief, I don't have to act in honor. I think that's the stupidest thing I've ever heard when people say that. I cringe when people say that. I don't act in honor. Listen, like I said, you don't like the way I fight, get out of the fight. That's all I can tell you. So with that being said, let's start. You're going to hear the clerk and them having a little conversation. And I said it might be a little hard to hear, but I just want to catch the key parts.
Yes, yes, I'm one of the clerks in the court today. She's just risen to read what you've given into the court this morning, so she'll be back in about 5 minutes. Yeah, the only thing, Jess, I have to say to you, because
she's just written, I think she said she just got basically the document you guys filed into the court today. And the one guy says the affidavit. So there you go, right away. They got the affidavits that we talked about, and that's this guy's been doing this for a while, but he knew enough to put the affidavit into the matter. I think he stated after like 37 hearings, a friend of his asked him to help this guy. So they're up around 40 hearings right now, I believe. And so he's had some experience, and he knew to get the affidavit into the court, because affidavits are treacherous for attorneys and judges. It handcuffs them. It's really a lethal weapon. And I've heard people say, well, it's a legal weapon. And listen, I don't care what you want to call it, a legal document or whatever you want to call it. And when you actually look at the The background of what an affidavit is, it actually goes back to King David. And so it's actually more a biblical document than it is a legal document. But he got the affidavit into the matter, and what you're going to notice here, because he did get the affidavit into the matter, you're going to hear the judge trying to, she'll say that, this case happened so long ago, and it's, and she's basically trying to, like, get him to take a plea. She wants him to take a plea. She's begging for him to take a plea. They just want to get something out of him, They want to get a plea from him. So you're going to hear the judge, do this little dance, and the judge is going to say some incredible things. We're going to go over some actually really comical things, and the prosecutor is going to say some comical things. And the beauty of this is you're going to see just how fragile these people are. That just how much of a house of cards this really is that they have here. There's nothing there. It's like in My Cousin Vinny, when he shows him the playing card, he shows him it's broad and it's wide, but when you turn it on its side, it's thin. There's nothing there, and that's what these people are. Their case is thin. They never have anything. So that affidavit you just heard him talk about, that's going to play a part in this. You're not going to see it, but this is why the judge is tap dancing, trying to get him to take a deal, because she goes, oh hell, he's got an affidavit into the case now. And if he knows how to use the affidavit, it's checkmate. And that's really what this stuff is. If you know how to use the affidavit, it's checkmate on the other side. So, all right, let's start it up here again.
During pandemic, unless you live in the same household, you can't actually sit physically beside each other. You'll have to be 2 meters apart. It's the rules. I'm not making the rules, but it's just...
We're all one family now.
It's the rules. I'm not making the rules. It's just the rules. This is like when they say to you, it's the law. I didn't make the law. It's the law. And we've been so conditioned over the years that we don't question these things. We haven't in the past. People don't question these things, and even today, people don't question it. Just the people I'm seeing in my groups, and the different chats I talk to, the different groups I talk to, they're singing it. And you can't. Don't let people talk to you like that when they say, it's the rules. It's just the rules. It's not me. It's just the rules. That's sort of like, the Nazi saying, listen, it's just my job. I'm just doing my job. I didn't make the decisions. I'm just doing my job. So when people talk to you like that, call them on it and say, who exactly rules are these, and where exactly did they get authority to impose the rules upon me? Because if they can impose rules upon me, I've got to be their property, or I have to contract with these people. And I know neither of those two options exist. So call them on it.
Yeah, well, I appreciate that, but just for the purpose of the court, if you're happy enough, if you want to take a seat, Mr. McIntosh.
Is your phone on silent? Yeah.
Yeah, actually.
Mr. McIntosh will have to sit 2 meters.
I know.
Select that for a reason that was really
Okay.
Ladies and gentlemen, Mr. McIntosh, I appreciate your case because I want every my sincere apologies.
Now, this is the judge talking, and like I said, a lot of it's hard to hear. There's a couple key things we'll try and pick up in here, but the overall thing is you're trying to pay attention to the judge. She's going to start talking about this happened so long ago, and and what she's doing is saying, hey, we really don't have much of a case here. This happened so long ago, and I think what she's probably alluding to is, I don't know their laws and their codes, but there are time limits even in their statutes for how long a trial's got to be. They can't run it out like an indefinite thing. And geez, when you're coming up on 40 hearings and stuff, it almost sounds like an indefinite process. We're going to do 80 or 120 hearings, and she's sort of alluding to that, and she's just trying to get this thing done with, because they know they're taking a whacking on this. That 40 hearings, they're getting killed financially with this, because they're paying these people to be here. And he's not being a good customer. He's not cooperating.
It's now 3 o'clock, and I'm sure you've been waiting quite some time. The case was very, very busy today with this, with the result that there were a number of contests, and I think because of the COVID restrictions, efforts were made to fix cases for a particular time, but unfortunately, none of them actually hit those times. I take it we are in a position to proceed with the contest now.
Yeah, I want to thank the court for giving me this opportunity. Anyway, I was going to say, sorry, what's your name so I can address it properly?
I'm Deputy District Judge Isaac, so at certain points within the case it may be necessary to speak to me. I know that you do have a Mackenzie friend regime at the minute. It's
A Mackenzie friend is like a friend able to help you with this matter. Okay, let's start it back up.
everybody stays at a distance, but if there is a need to consult at a later stage today, I'll afford you that opportunity. I'm anticipating that we'll be able to hear the case to its conclusion today. In a worst case scenario, I'm sitting again on Wednesday, so if it becomes necessary to go into another day, that's something that we can accommodate. I am going to say something at the outset, and if some time is required after I say it, I'm happy to give you that time, but it's a matter entirely for you. I obviously can't read the evidence in the case and prejudge it in any way. So in due course, I am going to hear from prosecution witnesses and then from any witnesses you may call or even from your good self about this alleged.
All right, all she's doing is she's just giving instructions on how this kangaroo court trial is going to run. And this part's not real important, but I just want to run it because the real important part's going to be up when he asked to talk to the prosecutor in private. That's actually comical. So I just want to run this for the time being.
I do, however, have in front of me the summons before the court, so I do know the nature of the charges, and I do know the alleged date of the offending.
Now she's lying right there. She's saying she knows the alleged things and she knows the alleged. Well, if you know the alleged, what she's saying is that everything she's talking about is hearsay. This judge wasn't there. She don't know anything. Okay, and don't let people do this to you. This is more stuff that it just drives me crazy. These judges and these attorneys do this. She knows the alleged. She don't know anything. She's got something written on a piece of paper that someone gave her, that someone told her. That's not personal knowledge. Listen, pretty much all courts, all legitimate courts, a witness must have personal, first-hand knowledge of a matter to testify to it. That doesn't mean somebody told it to them or they wrote it down on a piece of paper. You gotta have personal knowledge. So this judge is lying her rear end off when she's over there saying that she's got knowledge of this matter, this alleged matter. She's got knowledge of nothing.
What I'm going to say at the outset is that because these alleged offences occurred 5 years ago, and obviously that's a considerable period of time that's elapsed between then and now. That's a matter that would very much weigh with the court. For example, and I know that you're saying you're not guilty of these offences, but
now, I could have swore she said 5 years ago. So this case has been going on for 5 years. I mean, over a traffic violation, they had to have got hosed on this one. I mean, really hosed. This is how desperate these people are. I mean, when do you say uncle and say, geez, you guys been in here 40 times. We're getting hosed here. Let's let this one go. Now, this is just the arrogance of these people. So yeah, she knows that this is not good, and like I said, if they went and looked at their statutes or their codes, I'm sure they're probably past the limitation of being able to move this trial, because I think 5 years is very unreasonable time for a traffic violation. So I think that alone he could probably get this knocked out, but they don't want to tell him that.
all I wanted to say to you is this: someone who would plead guilty to an offence of this nature so far after the event would obviously get credit, considerable credit, for accepting the responsibility.
And let's go back and address that real quick. When she said you stated that you're not guilty, this is a statute junk crap that they do. Okay, here's when you say you're not guilty. When you plead not guilty, you're actually pleading to the statute, so you actually give the statute validity. I know that sounds weird to people, but that's how they take it, and that's how they're using it. Like, in other words, you're pleading not guilty, that it's not that the statute doesn't apply to you. You're pleading that you didn't commit the violation of the statute. So they're trying to claim that they need to now have a hearing to find out if you committed this violation of the statute. That's what happens when you're pleading not guilty. You're saying, the statute applies, but I'm just not guilty of doing what I was, of breaking the statute. So this is the sleazy dirtball language that these bar association legal society members do and use.
These particular charges are fine only offences. And it's unusual to deal with a case by way of any form of discharge. But an absolute or a conditional discharge is a possible disposal for offences of this nature if there has been a real gap since the date of the incident and the current time. Now, that would again depend on whether or not there is a criminal record, and that's something that I don't know anything about at present. And I would have to say to you at the outset that even if there were to be a discharge, penalty points are a separate aspect.
And here she is trying to get paid. Even if these charges or discharges, penalties are a separate thing. And hey, listen, we could discharge this matter, but you still got to pay the penalties. These are, these people are, they're parasites. There's no better. They are parasites. You want to talk about the most low profession in the world? It's being an attorney, okay? And I know people say, oh, there's some good attorneys out there. You know what? I haven't seen them. Anyone who takes advantage of somebody, basically they've locked up the courts, the legal system, and they've done this because they've dumbed us down and scared people, and because you're told to run out and get a lawyer and let the attorney speak for you. It's the worst thing you could ever do. And anyone who takes advantage of people like that, and this is all they're doing, they've got people coming to them and they drain them. They really do drain them for money. You got to pay them retainers and everything, little thing they do, they're going to charge you for. And these are slime balls. And they look at it. Look at their little rules. Well, we're going to discharge it, but we're still got to pay the penalties. These are the people you're dealing with.
Mostly carry penalties, even if there was no fine imposed. I'm saying to you, Mr. McIntosh, in fairness, because if you don't have a legal representative with you today, there's obviously no one making that point to you at the outset, and the fact that there can be credit given for something that happened some time ago. Obviously, if you wish to contest the charges, that's entirely up to you.
I think that I think it carries 4 points and this fine, but that's it.
Right.
Yeah, I'd say that. So but what we have here is this document. I don't know if you want to look at it, please.
Is that the document that you were going to have to hand in?
No, it's something else separate. Yeah. It's a show. Yeah, if you look at it, you'll just see where I violated.
I'm happy to look at that. Is that something that Ms. Murray has seen?
Don't believe so.
No. You've given it? No, I haven't given her that. No.
So this document, I believe, is their affidavit. And like I said, this is a nuclear bomb to judges, and it's a nuclear bomb to the attorney. Because the attorney's never going to answer your affidavit, and the judge can't dismiss your affidavit. Judges can dismiss motions. Judges can't dismiss affidavits. And this is why they don't like you using affidavits. And you stick your affidavit in their face, and you stand on your affidavit until somebody steps forward and rebuts your affidavit. I'm not moving in the case until slimeball attorney comes up and rebuts my affidavit. And don't let them push by your affidavit, because if you let them do that, you in effect are waiving your affidavit. You're hurting your own case. You stand on your affidavit. I'm not moving. Listen, I got an affidavit before this case. These are trained legal people. They know exactly what an affidavit is, and they know affidavits can only be answered by the party it's issued against, and it's got to be rebutted point for point. So if there's 10 points on your affidavit, you got to get 10 rebuttals. And if you don't get 10 rebuttals, or if you just get a lot of times what these slimeball attorneys will do is they'll give you a letter or a response to your affidavit. Well, then guess what? You've never gotten a response then. If you get a letter and it's not in the form of an affidavit, you don't have a response. So I would stick that back in Mr. Attorney's face. Hey, come on, man, you Mr. Fancy Legal Society guy, you know what an affidavit is, and you know that affidavits can only be responded by affidavit. So don't send me your crappy letter. I could care less about your letter.
You're quite right. The first charge before the court carries a fine, 4 penalty points, and the court has the discretion to disqualify for that. You probably read that as well.
Discretionary bond, yeah.
Discretionary. And the second one carries, in certain circumstances, 3 penalty points.
That's right.
In other circumstances, 2. As long as I'm sure you are
Fully
well
aware.
of that information. Yes, and this is in relation to the date in which you would give.
It was served. It was time bar. It was 3.5 years later.
I think that what I want to say in relation to that is, when you look at the,
it hasn't been signed or anything as well, by the way.
it's one of the reasons why this court would be prepared to consider dealing with you by alternative means, something other than a fine, because so much time has passed. But I'm entirely satisfied that the complaint was made within time. It seems from the paperwork that the court has.
See what she's doing is she's trying begging him to take a plea of some sort because she knows that, listen, they got a problem. There's so much time's passed in this matter that they got a problem pushing forward with it. And that's why she's trying to say, alternatives to the points, alternatives to this. She's just trying to pull money out of her pocket.
The complaint to the lay magistrate in April 2016. It's just unfortunate. So that is within 6 months of the alleged incident. The unfortunate thing is that you didn't end up getting summons until much later. So without...
What are you trying to say? Are we going to push with this trial, or are you trying to say that I don't understand what's happening there?
Okay, just to be clear about it, I noticed how old the offences were. Very practically 5 years.
Well, I was arrested and I've been in court 40 times. Not everything comes in the price of currency. I haven't slept over a year and a half if you know me dealing with this case.
Well,
So,
I am honestly focused very much on this incident and the road traffic offences. And all I can say to you is the court does have jurisdiction to hear the case, but I do understand that the incident itself was a very long time ago.
Now, she said, off you heard it, she said this court has the jurisdiction to hear this case. She's talking in doublespeak, famous by how judges and attorneys speak. Yeah, they may have they may be able to hear this case. That's venue. In other words, they may be able to hear traffic cases, but it doesn't mean they're able to hear this traffic case. And it's the same thing with you. Just because they could hear a certain type of case doesn't mean they can hear your case. So in a way, she's talking doublespeak here. She's saying, this court has the jurisdiction to hear this case. Yeah, this kind of case, but this court may not have jurisdiction to hear this specific case. Because in order for courts to have jurisdiction, they need personal jurisdiction, which means subject matter over the person, which they never can prove. And they need subject matter jurisdiction, which is also, unless there's another man or woman on the other side that you've harmed or damaged, they don't have subject matter jurisdiction, and they'll never get it because you can't harm or injure a fiction. And I don't care what they tell you, the state and the Crown, whoever, the Crown don't have rights, and the state don't have rights, and the Commonwealth of Pennsylvania doesn't have rights. Fictions don't have rights. So you can't injure fictions. So, like I said, what she's doing, it's a lot of doublespeak. Yeah, you can hear this, this court can hear this kind of matter, doesn't mean they can hear this particular matter.
And therefore, somebody who admits to doing wrong when so much time has passed could potentially avoid being fined for the matter and simply discharged, and it would be marked, obviously, as an incident. But the points would have to be imposed, that would have to follow. I know that you've been armed with quite a bit of information. Hopefully that makes sense to you. It's more difficult to deal with it by way of something other than a fine if it has to run and if you're found guilty at the end of that.
okay.
It's the sort of disposal that can normally only happen if someone accepts responsibility.
Can we just run with the case, please, Miss?
Certainly. So, employer first, what's my case? Yes, Your Worship, if I could call
Sorry.
Right, before
Sorry, start. He has to go out on as well. The witness, one of the witnesses, and I require to speak to the prosecutor as well, Judge, if you don't mind.
I think there has been the opportunity to speak with Ms. Murray, but I'm happy to allow you.
No, you're not miss much with the job. I know it's hard to hear, but from the judge, her all are babbling. She must have said 3 or 4 times about how long this case has been, the time that this has taken. She's sort of showing her hand. She's telling you that they're not real comfortable with how long this case has taken. And like I said, she's really begging him to take a plea deal, and he's not up for it. He's not hearing it. So what he just asked her, he said, listen, she was getting ready to start this little kangaroo court trial, and he said to her, "Hey, listen, can I speak to the prosecutor first?" And this is the core of the meat of the video, because this is where it gets interesting and fun.
Speak again if you wish. If only the officer who's on the point of giving evidence would remain in court, then please. I'm going to rise and allow you to speak to Ms. Murray.
Miss Murray, can
Yeah.
I take your name and all, and one of them have to go in. One of you's have to go today. Miss Murray, can I take your name? Can I see proof of your agency, please? This proof of your agency.
Can I see proof of your agency? Killer question. This is what we were talking about earlier. She don't have proof of her agency. She's gonna dance here, and she's gonna say, I think she says the Crown. I'm like, yeah, who's that? Mr. or Mrs. Crown gave you agency. When he's asked for agency, like I said, he's asking for who's the principal, who hired you, what are you doing here? I don't know who you are. So we're stupid. We just fell off a turnip truck. We don't know anything going on. All we know is this lady's here. She's claiming she's involved in this matter in some way. I don't know who this lady is. I never did anything to this lady. Hey, who hired you? What are you doing involved in my matter here? Who hired you? And this is the Achilles heel that no one ever hits, and he's going to hit it right here. And this is what I'm telling people is, don't let these attorneys get out of the box. Don't even let them get started. Go after their agency right away. I did it with the sewer authority attorney, and it drove him nuts. And the guy who thought I was a dummy and didn't know what I was doing, yeah, they pulled him off his own case a month ago. He got pulled off his own case because I banged him over the head with stuff like this. Who's the principal that hired you? And he just flummoxed and tripped over himself, and so don't let them get out of the box. Go after their agency right away.
Certificate, insurance detail, a copy of your court bond as well, just in case.
What do you mean by agency?
What do you mean by agency? Now, listen, this is an attorney that went to law school. She don't know what agency is. What do you mean by agency? She knows full well what he means by agency, and she's sort of caught by this question. You get caught by a question, you try and buy yourself time. That's exactly what she's trying to do here. She's trying to buy herself time till the hamster gets on the wheel in her little brain there and can try and feed her an answer, because right now she's sort of out there on an island by herself.
I'm self-employed.
I'm self-employed. What's that got to do with anything? What's self-employed have to do with who hired you?
I have no agency.
I have no agency. I have no agency. So I don't have a principal. I'm just freelancing here. I'm here by myself to prosecute this case. I don't have any agency. I'm just prosecuting myself. I'm going to prosecute this case myself. I have just decided to kill some time and prosecute you.
No, I'm instructed by the Crown.
I'm instructed by the Crown. Was that Mr. or Mrs. Crown gave you that instruction? I mean, I'm instructed by Mickey Mouse or Donald Duck. That's what I hear when somebody says, I'm instructed by the Crown. Yeah, I'm instructed by Mickey Mouse or Donald Duck. Mickey Mouse and Donald Duck told me to do this to you. I mean, this is really what she's saying when you break this down. This is insulting, okay? To a normal thinking man or woman, this is insulting, and that's what these attorneys are.
You have to prove who you are.
Well, I'm telling you who I am, and
I'm telling you who I am. Hey, listen, I have to prove nothing. I could tell you who I am. How stupid does that sound? I could tell you I'm just telling you who I am. Well, I don't care what you tell me. I need to see the principal. Who the hell hired you, lady? I don't know who you are.
well, I can show you my Bardarby pass, but I don't actually have to show you anything.
I don't have to show you anything. I could just do these bad, horrible things to you, trying to extort money from you, steal from you and your family. But I don't have to show you nothing, because I'm a magical being. I'm a magical, special being. I'm a member of the legal society. I'm a bar member. I could just do anything I want to do to you. This is exactly what she's saying.
It's an MIS. It's not hard.
Now, listen, also what he's doing, he's trying to get the spelling of her name. And listen, you want to intimidate somebody? When you write their name down in front of them, just don't write their name down. If you know it, make them spell it for you. Try and get them and show them, let them see you write their name down. because believe it or not, that's an intimidating thing for somebody, because they're thinking, why the heck's this guy writing my name down? Because people don't write names down unless they're going to do something with that name. Okay, so if he keeps asking for the spelling, and she's getting more nervous and more nervous.
NS. The fact that I'm here is
Can I
proof
ask
of
you-
agency.
The fact now she's going. The fact that I'm here is proof of my agency. Whoa! The fact that I'm here is proof of my agency. What has that got to do with who hired you? Who's the principal that hired you? The fact that I'm here is proof of my agency. Now, listen, she's either a slime ball and trying to dodge the question, or she's dumb as a rock.
Actually, what's your? Can I ask?
I'm sorry, I'm going to speak to Mr. McIntosh.
In order for me to understand the nature of this, all right, I want to know what's your probable cause.
In order for me to understand the nature of this, I need to know what's your probable cause. In other words, what's the crime? That's what probable cause means. Probable cause is a crime. Okay, crimes are basically for anyone to be involved in any matter with these people, there has to be probable cause. You had to have damaged or harmed another man or woman, or violated somebody's rights. And if you don't, there's no harm or damage, you don't violate anybody's rights, there's no probable cause. So that's what he's asking her. Listen, if this is a traffic violation, did he, listen, he didn't damage her, okay? She's got no standing in this matter, and you'll hear him hit that. And the Crown, he didn't damage the Crown either. So she's trying to say the Crown told her to bring this case. We don't know who the Crown is. It's Mickey Mouse or Donald Duck told her to bring the case. And so the Crown didn't get injured, and she didn't get injured in any way in this matter. So she's just sort of dancing. She's stuck.
What's your cause?
My cause is that you were arrested because you failed to work the felt and field by the specimen threat.
My cause is that you were arrested. And how did that harm or damage you, sweetie? It didn't. Okay. And this is where in the future, when they get into doing this with somebody, because I'm sure they're gonna have another opportunity to do this, if they say something so stupid like that, it's what she said. Well, you turn around and you state, well, exactly how did that harm or damage you, miss? I don't understand. How's that probable cause? Because she's not harmed or damaged, and the Crown's not harmed or damaged, so there's no probable cause in this matter. So we just learned that there's no agency. She can't prove a principal hired her, and there's no agency in this matter. There's no probable cause in this matter. Nobody was harmed or damaged.
Who made the complaint?
The police.
Okay. What is your standing in this court?
Who made the complaint? The police. He didn't harm or damage the police either, okay? So now we've learned that nobody's got standing in this matter. Nobody's been harmed or damaged. There's no standing in this matter. And that's what he just asked her. What's your standing in this matter? And I've hammered this a lot on different videos and interviews I've done. These attorneys have no standing because he didn't harm or damage the attorney, and he didn't harm or damage the Crown, and he didn't harm or damage the cop. So there's no standing. Now wait till you hear this little dance she does.
Again, Mr. McIntosh, I am not on trial here, so
Again, Mr. McIntosh, I'm not on trial here. I could just do things to you, Mr. McIntosh. I'm a special, magical being. I'm a member of the legal society. I could do anything I want to you. I'm not on trial here. No, you are on trial, okay? You are on trial. And he's putting you on trial right here with these questions. He's putting you on trial. And you're sweating bullets right now.
I shouldn't have to answer any of these questions. If you want to ask something about the case, I can answer questions about the case, so I can answer questions.
Lie. She says, if you want to ask questions about your case, I can answer questions about your case. Lie, 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 lie. She's got no personal knowledge of anything in this matter. So if she's got no personal knowledge, everything out of her mouth is hearsay. It's what she's reading, written down on a piece of paper for her, or what was told to her. So she just lied again there. You want to talk about racking bar the bar grievances of violations up? She's going one after the other, man. They're just starting to pile up now. She's lying her rear end off.
I just. No proof.
I can answer questions about what happened on the 13th of March 2016, but unfortunately,
She can't answer questions about what happened on the 13th of March. She wasn't there. She's got no personal knowledge of it. She's not. First of all, she's either got to be counsel or she's got to be the witness. She can't be both counsel and a witness, and she can't speak for the plaintiff. Now, this is in their fictitious legal screwed up world. They have these attorneys speaking and acting for fictions. Well, that might work if you're speaking and acting for a fiction against another fiction. But when there's another man or woman on the other side, like this guy's a man here, she's got a problem here, and she's starting to figure this out.
Not, I can't answer anything else. Yes, I'm quite happy.
Quite happy to go in.
Because the judge,
And you'd
the
be
judge has
liable.
my
You'd be
opinion.
liable and all for if I need to bring
I'm not
prosecution
liable for anything in respect of
I'm not liable for anything. You say so you know you're going to be liable. I'm not liable for anything because he did ask for a bond before. I'm not liable for anything. I could cause any harm or damage to you I want, and I'm not liable for my actions. Bull. Okay. She's definitely liable for her actions, and she knows it. And you're gonna figure out what she says with the judge. She knows that she's liable.
All right.
my provision says that I'm a barrister at law and I'm self-employed. That's my provision says.
You have a choice. Right. Call the judge, please.
All right, so he's giving up on her. He's not going to get no answers from her. She can't give him any answers. So he said, call for the judge and get the judge. And what you're going to hear is the judge is going to start this little kangaroo. Well, going to give instructions to start the kangaroo court. And what's going to happen here is after the judge starts speaking, you're going to hear the attorney jump in here and sort of say, hey, I'm not comfortable prosecuting this matter. I feel threatened. I'm threatened. He's asking me for my insurance. He's asking me for standing. How dare he? Agency? My God, these horrible questions he's asking me. I feel so threatened by his questions. This is the mentality of these people.
My first officer, that was about to be called, hasn't yet been sworn. Just to say at the outset, it's extremely important that when the witness is giving his evidence, there are no interruptions at all. We're already at 3:30. And I'm concerned to get the hearing dealt with today. And we will have the opportunity to ask questions of the officer, but there are limitations on the questions that can be posed on this court.
Even this, look, you will have the ability to ask the officer's questions, but it's limited what you can ask. This is tying your hand behind your back and asking you to fight them. Hey, listen, we're going to come smack you in the head with a baseball bat, and then we're going to tell you how you can fight back, okay? We'll give you some rules after we smack you in the head with the baseball bat. We're going to tell you how you can fight us back. There's no limitations. Listen, if this officer, these scumbag officers are going to make claims against him, guess what? I can ask that guy any question I want. That's due process of law. They don't get to tell me how I have to fight them back. And that's what these rules of civil procedure. When she's saying this is limited, that's limited, she's moving according to the rules of evidence, rules of civil procedure. These are things written by the legal society. So now they punched this guy in the head to start a fight, and then he's going to fight back ferociously. And she's going to tell him, well, listen, we don't like the way you're fighting back, so we're going to create these little rules here that you got to follow. You can only fight us a certain way. Bull. I go all out at them, all out at them. I'm not going to let anybody tell me what I can and cannot ask. Are you kidding me? It's just a ridiculous claim.
We'll interrupt any questions asked or
Judge Iris, Mrs. Morris failed to give me proof of agency and her insurance details as well.
Now this is great. He's telling the judge she failed to give me proof of agency and proof of her insurance details, her bond. Wait till you hear what the bull that comes out of this judge's mouth. You want to talk about making it up on the fly. Wait till you hear this.
Can you clarify who she is, and who she works for, please?
Ms. Murray is the prosecutor today, and there is no need to do that. This court is obviously very properly constituted, and there is no harm to do that at all.
That's a classic. Listen, Miss Murray's the prosecutor, and there's no need for any of the agency stuff because she said this court is very properly constituted. What the hell does that mean? This court is very properly constituted. Very properly constituted? What does that mean? We've very properly constituted the court, so we can just let people come in and just make crazy claims against you without any evidence of who hired them or what they're doing involved in the matter. This judge is a piece of crap too.
At the outset, today and we'll call the first witness.
Which I'm not quite sure if I'm content to speak to the certain questions that were asked of me and the manner and certain threats made that if I didn't happen. I'm not quite sure I'm in the best position to speak about it.
Well, Ms. Murray, if you've been unsettled by anything that's happened while this was not being sitting, then that is very unfortunate. I know you've been here all day and being as I was to the case. If you're telling me you're not happy to prosecute the case, then I will accept that from you. Being your
Miss Prosecutor just bowed on the case. She's not comfortable prosecuting this case, and she felt threatened. She feels threatened in this matter because he asked them terrible questions. Who hired you? What's your standing? And are you insured for the damage you're causing me? So she felt very threatened because, yeah, she should feel threatened because he should launch a bar grievance against her rear end. And not only should he bar grieve her, he should file a notice of claim against her also. Go make a financial claim on her too, so that she's got to turn around again and tell her insurance company that a claim's been filed against her. She's squirrely. Listen, these bar grievances, I heard an attorney tell, Ryan told me the attorney told him that the prosecutor was coming after him. Oh, I don't care about bar grievances. I've had a ton of bar grievances filed against me. Bull. If he had a ton of bar grievances filed against him, he wouldn't be an attorney. And she's a little worried here. I don't know if she's a first-year attorney. These are kind of cases. First-year attorneys get these little traffic, violation stuff. They're nothing cases. And she's a first-year attorney. And I know over here, from what I'm told, is first-year attorney gets a bar grievance, probably going to lose their insurance. Can't be an attorney no more. So if it's sort of the same thing over there in Ireland, she gets a grievance against her, and she's a young attorney. She might be done. That's why she's fleeing the ship right here. She wants out. She wants nothing to do with this case.
I think there may be some compromise now to the position, Your Worship.
I think this is very regrettable, Mr. McIntosh. Like you, everyone wants the case dealt with today, but I am concerned about what Ms. Murray.
Oh, the judges, she found it regrettable. She wanted to wrap this case up today, and poor Miss Murray there, she's bailing on this case, and here's the funny part. Miss Murray got paid for that day too. And the judge got paid, but he's not getting paid. And this is what I like to see people start to do is, you know what? Start bringing bills in and give them to these people when you show up to these cases. Give them a bill. Because, listen, the prosecutor's getting paid, judge's getting paid. You're not their property. They don't own you, and you don't have a contract with them. So if they want to order you to be somewhere under force, threat, and duress, go bring them a bill. Go bring them a nice bill, $1,000, $2,000 bill.
Not push on today. I'm sitting again on Wednesday of this week. If the two officers are available on Wednesday of this week, then that is an alternative. Rather than listing early in the day and have anyone inconvenienced unnecessarily, I can check to see how busy the list is and potentially push it into 2:30. And hopefully by that stage, all other.
Now she's trying to schedule another hearing for these guys to come in, and that's one of the things I would tell them not to do. I would have told them, listen, no, Miss Prosecutor's going to bow. I'm going to move that you end this thing here because this is getting ridiculous. We're running. How many years are we into this? And now I got a prosecutor bowing on me. What are we going to do this till? Maybe when I'm 60 years old, we'll still be running this case or what? No. No, I would have ended it right here. Now you motion to dismiss this right here. This is getting ridiculous, and. So I think they did agree to come back in this matter, and I told them what to do. Basically, you state that you're not coming back for the trial. You're coming back to get discovery. You want to get the new prosecutor's name, his proof of agency, and you want to get his bar number. You want to get his standing, what standing he has in this matter, and you want to walk him down the same path you just walked this prosecutor down. And that's the only reason you're here is for that matter. That's the only reason you showed up was for that matter. Because you've got these fictions fighting you. You got these attorneys speaking for fictions that are trying to cause you harm. These are crimes that are being committed. This is not funny stuff. I'm laughing because the absurdity of it's just comical. But these are crimes. These people are committing. These are blatant crimes.
2 seconds. Yeah, Wednesday is good for us.
I'll just check.
Yeah. Has to be Wednesday now because I need to. It's my birthday. See, I'm coming 34. I need to push on with my life. I need a balanced life, you know.
That's great. Listen, my birthday's coming up. Listen, I need a life. You people you're taking over my life with this stuff. I need a life. I'm tired of you people.
So it has to be Wednesday.
But your actual birthday's not Wednesday.
I know. Yeah, well, I want to push on.
Well, we're keen obviously to do this case. We're just going to check perhaps if you will check this list.
There is a case listed at 2 o'clock, so maybe if you want to
No, it's not in the same.
I have.
It'd be in this courtroom.
Can I have it in a wee bit of writing there from somebody, please, to say that I'm in for half? Can I have it in writing just to say that I'm in for half too, just on
Yes,
my-
no, it go on the system as after.
So
We
we-
have it listed.
And could I check, someone check with the other officer if half two on Wednesday is suitable for him also? There's an officer who's waiting outside.
You check with Chris to see if he's free on.
Mr. McIntosh, would you be content with my getting Miss Wilkinson to send you a confirmation?
No, TPS has barred me from their
No,
place.
Jennifer, would you deal with in our office downstairs?
Just give me a wee note there and just put your initial on it. Can I have your name just to see? You're the clerk, aren't you?
Yes, Mr. McCartney.
All that's happening is we're checking the officer.
It's good he's getting names. Always take names. Get everybody's name that's involved in the matter. Get them all. Because that, like you said, makes people nervous when you write their name down in front of them. Because they're thinking, why did you write my name down? Because people only write names down when they're going to do something with them.
Search are available to That pose any difficulties? Thank you very much.
Obliged, Your Worship.
Thank you very much.
Thank you.
Thank
I
you.
know.
Wednesday at 2, and that concludes all other matters on the list.
does,
Is that correct?
The prosecutor was too shy to go. She ourselves just says she didn't want to feel comfortable going with us.
Right, so back again next week.
No. The prosecutor.
Oh, 2 days, this Wednesday.
The prosecutor didn't want to go. She just
All this time was down.
They were trying to get me to agree on what was it?
Back away.
And he's talking, these are the two guys talking. He said that she was trying to get me to plea, and she did that from the start of the trial to the end. She's dying for him to take a plea. Please take a plea because we're in a real bad position here. You just put an affidavit into this matter. This is like been going on for years. This matter, and we really can't really defend ourselves with what we're doing. That's why she wanted to plea.
She ran away scared because she has no fucking authority. She has no fucking authority.
She ran away scared, and that's exactly what happened. She ran away because she was scared. And there's a little part in here that'll be coming up, and he's going to be talking about the bar grievances. First bar grievance for the first-year attorney, they lose their insurance. It's experienced attorney. If they get 2 bar grievances in 1 year, there's a good chance they're going to lose their insurance. And if a law firm gets 3 bar grievances filed against them in 1 year, there's a good chance the law firm's going to lose their insurance.
She's not insured. Can't be covered because that means anything she does not quit. She's personally liable for it.
She's personally liable for her. That's what scared her. Everything was going on there. She was personally liable for. I doubt anyone's ever called her on that before. And once these guys called her on that and reminded her of that, she got rattled.
Now, what else? What else? Is that I can't quit. Is that we're going to write the head bar to Scotty Insurance and report her for insurance company.
Yeah.
Now, take your head insurance company. Take your barrister and take your past the bar settle. You're in your first year. You get 1 complaint.
Yeah.
You lose your license. You can't practice anymore.
Your insurance goes up,
Now, no. If it's your first year practice, you get 1 complaint. Your insurance is pulled and you can't practice anymore.
Is that it?
If you're over 2 years and you get 2 complaints in 1 year, you lose your license. You can't practice anymore. You're just over when you're going to apply to your bar out of your insurance and see what your insurance company thinks. If you practice in your license authority, that you're
He just went through the 1, 2, and 3 bar grievance thing. Basically, that's that these attorneys will act like they don't care about the bar grievances. They're not worried, and bull. They're real worried because these insurance companies are ruthless with them. Listen, it's a numbers game. They don't care about these attorneys. I think there's like 48,000 new attorneys a year to come out of the U.S. alone. So they're not worried about these attorneys. Anyone who's a threat to them, to the insurance company, it's going to cost them money. They're going to move on and get they got people lined up to get insurance. They're not worried about Mr. This attorney. They're not going to go out on a limb for this attorney.
First level. So we're gonna fuck up your shoe. We're gonna put you in first level. See what's going. Probably I don't have to do this. Alright. If the next part then nobody wants to get after that. There's no walking. What they don't want to take the case on. The judge doesn't want to take the case on. He's begging you to ask for a plea.
They don't want to take the case on. The judge doesn't want to take the case on. And they know it. They figured this out. They know that. Listen, I don't know if a new prosecutor wants to come in and take this case on, because he's going to hit the same wall. He comes in, he's going to get smacked with the same questions, and he's not going to escape it either. So what these guys did, they just basically showed them their liability. Listen, here's how you're liable here, guys. You want to keep doing this? Let's get it on.
He's begging you to take a plea.
She's begging you to take a plea. She's begging you to take a plea, and that's what she's been doing the entire time.
And please don't
And I give her my.
walk off the floor. How many times have you seen that happen? How many times have you seen that happen?
He talked about the prosecutor. He said, "I've never seen a prosecutor take herself off the case." How many times did you see that happen? How many times have you seen that happen? How about like never? And like I said, that's the power of these questions.
I don't want to go on. He's not playing right.
I don't want to go on. He's not playing right. In other words, I don't like the way he's fighting. I want to be able to punch him in the head when I want to punch him, but I don't like when he punches me back in the head. And that's exactly what this is.
The judge wanted to. The judge wanted to. Yeah, the judge wanted to keep herself. She was no.
Okay. And you have to say, you're on the arrest. I'm carrying on the arrest.
That's pretty much it. I just wanted you to hear just how look at those basic questions he asked her. He asked her about her agency, and she played dumb and she didn't know what agency meant. Come on, man, you're an attorney. You sure you got to know what agency is. He asked her for her standing in the matter, and she's got no standing, which means, what are you doing in this matter? Why are you involved in this matter with me? And he asked her for the probable cause. In other words, what crime's been committed here? What exactly are you trying to prosecute? What crime are you prosecuting? And she couldn't even articulate the probable cause of the matter, which meant the entire thing is built on fraud. So get used to doing this with attorneys. These are things I put in my paperwork early on, where I'll go after the attorney's agency. I don't even know who hired this guy. Who the hell is this guy? What's he doing involved in my matter? That bar card doesn't give him any more rights over me than any other thing. Okay. No, we're not equal. I'm actually superior to the attorney, because I'm a man. He's playing a part of an attorney. As long as he stays in the part of an attorney, I'm superior to him. I'm gonna bang him over the head with that affidavit every chance I get. So don't let the attorney get out of the gate. You don't take. One of the things I was taught is you don't cede any ground to them. Nothing. Like I said, if they say it's sunny outside, you run outside and you check to make sure the sun's shining. Because you don't give them anything. You make them work for everything they have. And listen, when you show up to a trial or a hearing like this, first thing will happen is the attorney they state their appearance. They make their appearance. I'm John Michael Sheridan, appearing for the Sewer Authority, and the monkeys, the normal monkeys, don't know any better, and they don't object to that. Because first thing I do, objection. I see no evidence that he's representing the Sewer Authority. Is the Sewer Authority here to testify? And that judge, if he starts trying to stick up for Mr. Attorney, I'm going after the judge too, because now the judge is now he's actually acting like the prosecution, because now he's taking sides. Listen, he's either got a principal he can bring before me so that I can question him to find out who hired this guy, or he doesn't. And I don't need Mr. Judge to run interference for him. And if Mr. Judge is going to run interference for him, well, now Mr. Judge is testifying against me, and I'm going to come after Mr. Judge with both a bar grievance if he's still got his bar card, and I'm coming after him with a judicial complaint. So don't let them get out of the gate with this stuff. Jump on them and use their insurance against them. Bar grievances are lethal to them, and once you hit them with that bar grievance, then you take your affidavits that we all talk about, the affidavit of status, affidavit of fact, and take the document that Mr. Attorney sent you, because that's complete fraud. Go through that document, circle everything on there that's fraud, number it, and on a separate piece of paper, list everything on there that's fraud and why it's fraud. Because that document it's junk, it's garbage. And in addition to that, when you get that little fraudulent document from Mr. Attorney with his official seal on his envelope to try and intimidate you, his bar partner, his law partners on there, that's supposed to intimidate you, a law firm writing you a letter, go file a mail fraud complaint against him too, because everything in that letter's fraud, and he's trying to extort money from you using the United States Postal Service. So go file a mail fraud complaint against him, and the bar grievance against them. And what I like to do, some people don't want, like, I don't want to tell them I'm going to do it. I'm just going to do it, but I do like to show it to them. It's like Sonny from Bronx Tale. When he beat the bikers up, and at the end he takes the biker's head and he picks his head up and he makes him look at him. He goes, look at me, I did this to you. So what I like to do is I like to include the copy of the mail fraud complaint and a copy of the judicial complaint. I want them to know I did this to you, and I'm not done coming at you. I'm going to continue to do this to you. And like I said, this is just the preliminary stuff, and this can do damage. This stuff, you seen that attorney bail. Just this preliminary stuff can do damage to these people. So when you start moving them through like the notice of claim process after that, where you're making a financial claim against them, and then you start filing state and federal criminal complaints, well, that's a whole other mess. Because my God, if they get indicted on one of those criminal complaints, they're done. Their careers are done. That'll scare the hell out of them. Suddenly, they're not worried about you. They're worried about protecting their rear ends and their livelihood. And your cherry on top is when you actually file a formal judicial claim against them for violating your constitutionally protected rights. And that's not hard to do when you construct it right. And if your paperwork's put together properly, and especially after your paperwork, the things you're going to have against them, because you're going to have them in default on these affidavits, and you're going to have them nervous already. When your paperwork's put together properly and you filed against them, like the actual judicial claim, they're not going to want to come into court with you because they're not going to be able to answer your filing. It's unanswerable, because we know what they're doing is fraud. And when I write it down on a piece of paper and file against them, and I become the moving party against them, now they got a problem, because now they have to give me answers. And if they're going to sit there and try and lie in their answers, they're going to get smoked. And this is what they're afraid of. They're afraid of things like this coming out, and people understanding the process. And that's why it's so good to see a lot of people throughout the world right now. It's funny. I did the Crow shows, and think I'm reaching just somewhat of a local, the country area. And now we got people in Bulgaria, we got people in the UK, people in Canada, people all over the world that are now filing stuff and taking actions against these people. And this is a real effective way to fight them, because through this, it's built on a common law principle, but these are basic rules that they have to follow. If you're an agent, there's got to be a principle. You've got to be bonded. They've got to have insurance. These people, they can't work. So you have every right to ask for their insurance bond, because these people are trying to cause harm and damage to you. Well, listen, I need to know, make sure you got to make sure you're insured. It's like sending somebody out on the road with no insurance, which you can do, but the danger is, my God, if you kill somebody or harm somebody in a multi-million-dollar suit, it's going to wipe you out. Same thing with an attorney. You know, they cause harm and damage to people. They better have adequate insurance to cover the individual they're coming after, or the man they're coming after. Let me say that. I hate to use individual, Mr., Mrs., but they need to have insurance to cover these people. And when you start poking down around there, and they'll get nervous because they're not used to the monkeys doing this to them. So, like I said, you don't have to be a law expert to do this stuff. You just have to take some time, watch the videos, do some reading, and apply this stuff. You know, like when you download the documents, don't just copy them. You know, read through them, try and understand each point. And if you don't understand a certain point, jump on the Telegram group and you know, put it in there. Say, I don't understand what Alphonse means in point 4. And guarantee there's like 1,500 people up there. Somebody's going to know what that means in there, and they're going to be able to explain it to you. Because you want to be able to explain the documents. You need to know what's in the documents. Don't be like the other monkeys and go print something off the internet and go take it in court, because what's going to happen is the guy in a black dress is going to ask you a question, and you're going to fall on your face because you don't know the underlying principles of what's in that document. You need to know what's in that document. And listen, those documents, I'm no great teacher, but I'm telling you, those documents, there's a lot of good stuff in there as far as getting your mindset right and how to defend yourself. These are just basic common sense things in those documents. And if you can understand them and articulate them, you become a force against these people. And when you know their Achilles heels, which I'm showing you now here, these you know, their insurance is their Achilles heels. And when you come after their insurance, you're coming after their livelihood. Because if they lose their insurance, they can't work. They lose their careers. And I don't think anybody wants to lose their career coming after you for a $200 ticket. You know, they'll start to back away from you real quick. So, you know, just want to give you a little rundown of this. I mean, I thought it was a brilliant thing. I really laughed when I heard, you know, especially the line from the judge when she said that this court is very, what she said, it's very, it's very constituted properly or something, some ridiculous stuff. Like, that was not the real answer. You know, in other words, that was like a sidestep by the judge because she couldn't give a legitimate answer. And these people live in the world of doublespeak. And get in the act of using the Socratic method where you keep asking them questions. If somebody gives you an answer, keep asking them, well, what evidence do you have of that? And then you give you another answer, well, what evidence do you have of that? And what's eventually going to happen is they're going to paint themselves in a corner that they can't get out. And you'll know they can't get out when you paint them in a corner and the next word out of their mouth is, well, you got to talk to the attorney or my attorneys, or because this is, especially when you're dealing with your local people, your borough people, your township people, they're button pushers. They don't know what they're doing, and they rely on these attorneys. So the attorneys are the puppet masters controlling all this stuff, and the Bar Association, the legal society, are the puppet masters of this world. Don't kid yourself. They're running all this stuff. You know, they are the man behind the curtain in the Wizard of Oz. They are controlling everything. Okay, so learn what their weaknesses are and expose them and bang them on them. And listen, you do this quickly and early. It's like a fight. Don't sit there and wait and sit back. As soon as they come at you, you run at them full speed and hit them, because that'll disorient them. It's like a fight. My dad, we used to be friends with a professional boxer, and he worked with him when he used to work at Boeing after the guy retired. And he told me that, you know, if you ever get in, listen, he told me first, don't try and get in fights because you don't know who you're messing with, which is true. But he said if you get forced into a fight, you know you're going to be in a fight, make sure you land the first punch because it disorients the other guy. Well, when they're throwing their junk at you and you run at them with this ferocity and you're filing paperwork that's supported by affidavits and you're filing bar grievances and claims and criminal complaints, that's like taking a sledgehammer and hitting them in the head, and that's definitely going to disorient them. Not only is it going to disorient them, it's going to scare the hell out of them. And my goal is I would love to see the bar society, the legal society collapse, because these people are parasites and they're really not needed. I'd love to see us go back to the old ways where man had dispute against a man, they went before, you know, an impartial judge, and the real facts were brought out. Not these dumb codes and statutes and you know, these rules of civil procedure, which are nothing more than a way to usurp your rights. That's all they're there for. So just wanted to give you this call, this little thing here. Like I said, I think this is a very encouraging thing for most people because you all can do this. You all can do this for any matter you're involved with right now, which probably a lot of things are traffic tickets and mass citations. And let me say on that matter with mass citations, I know of an individual who basically went 30 for 30 in like people getting kicked out of stores and suing in federal district court. So don't let them make you believe that this is frivolous and you can't do nothing about this. Put your paperwork together properly, cite the right stuff. You can clock them in federal district court, even in their system under Title 42, 1983. And listen, I'm not going to criticize anybody. Listen, the main goal of this is to get paid, okay? And I know there's purists out there. They hate to use anything these people have. But you know what? I know a guy that steps into Title 42, 1983 suits and call himself the plaintiff, whatever, and he has cleaned their clocks. Tens of millions of dollars he's cleaned their clocks. And he's used Title 42, 1983. And I'm going to be honest, I haven't seen, almost no one that I know of has, first of all, no one's near this guy's success. And he's the only one I know that's really getting paid. And these are just not a few matters he's gotten paid on. Numerous matters he's gotten paid on. And I don't believe he's ever lost a case. And he's not an attorney. He's a guy who applied himself. He did a lot of reading and a lot of studying. So don't get hung up on, you got to use certain tools at certain times, even if it's their tools at certain times. If it's to your benefit, use it. I mean, don't get hung up on being a purist. If you can use their tool better than they can for a certain situation, use it. Don't be dumb. Don't be like, oh, I got to be a purist. Like I can't use any of their stuff. I can't. No. You use what benefits you. Whatever helps you, you use. So don't get hung up on like things like that, and don't get hung up a lot of times on semantics and certain words. And listen, it all comes down to, does the other side have any witnesses, and does the other side have any personal knowledge of anything? Because if there's no witnesses and there's nobody come in and testify with personal knowledge, they don't have a case against you. And I'm going to tell you right now, 95% of these cases, they don't have witnesses. The cop's not a witness. What's he witnessing? That you broke a code? That's an opinion. I mean, how's he prove the code applies to you? Because they said it does? If someone, like you said, if somebody can write something down on a piece of paper and make it apply to me, I got to be their property. And the other way they can make that code apply to me is if I contracted to it. I agreed that the code applies to me. I haven't done either. And if I haven't done either, they got a problem. And it's just, you have to sort of unwind your mind and separate your physical location with written documents. Because they're famous for that too. To make you believe that because I live on the geographic physical land known as Pennsylvania, they want me to believe and other people to believe here that the Commonwealth of Pennsylvania's laws, statutes, codes, and ordinances apply to me. Well, they're two separate entities. One's a geographic landmass, and one's a municipal corporation or a corporation that exists only on a piece of paper. It's a fiction of the mind. They're two separate things. So just because I live on the geographic region of Pennsylvania doesn't mean some company's codes apply to me. Like I said, that's like me, the church saying I live in their parish, and because I live in their parish, I got to give them $100 a week. It's just a ridiculous claim. You wouldn't take that from the church. Why are you taking it from these local municipal corporations? Because that's what they're doing with their you need a permit to do this, you need a permit to do that, or we could tax you for this, we could tax you for that. Well, you know what? When I started challenging that, I'm starting to see a lot of people running away from me. These local people, they're a little scared because they know I'm not the average monkey. Like you said, I'm no genius, but I just know enough that I could hurt them. I could really damage them, and I don't mean physically. I'm not out to hurt anybody. And like I said, I'm not out there to hurt anybody financially. But if you want to get in a fight with me, and you don't like the ferocity of the way I fight, the ferociousness, then get out of the fight. Don't stay in the fight with me. I didn't start the fight. You can't get in a fight with me and tell me how I'm going to fight you. Sorry, it doesn't work like that. So if you get in a fight with me, watch out, guys, men and women from my locale who probably monitor me from what I was told. Watch out. I'm going to clean your clock. And I'm going to clean your attorneys' clocks. Your attorneys are never going to get out of the gate. I'm not worried about your attorneys. They could take those bar cards and shove them where the sun don't shine. I don't really care. So, but use this stuff. I mean, this is, you're seeing this now starting to trickle in. People having successes, and there's something you just watched there. 40 hearings going on, and look, the prosecutor runs off the case. And now they got to find some sheep to bring to slaughter. Now the next prosecutor, he's going to have a problem too with these guys because I've seen what these guys have yet to come, and woe is the next prosecutor that comes forward because they're going to get clocked. So that's it. I don't want to go on too long, but just know that this stuff works. I mean, you're seeing it firsthand here. This is not patriot lore or myth or. This is stuff that works, and because it's based in business fundamentals. Insurance is fundamental to these people. They don't have insurance, they don't work. All right, so I'll let you guys go. Keep your head up. Don't let these people get you down. They are not who you think they are. Take care.